came across this book. I bought this book years ago, and I read it when I first started practicing law, and I found it in my basement amongst all of my books, and I brought it to my office, and I was flipping through it this morning. It's written by Brian Garner, who used to be, and maybe he still is, the editor for Black's Law Dictionary. And I can remember the first time I read this book. I hadn't practiced law more than a year, but it's even more true now. I remember this statement about writing for, quote, a mythical judge who might someday review the document. He says, today, the prevailing attitude, unfortunately, is that lawyers should draft contracts, legal instruments, in statutes with the judicial reader in mind. But this approach is wrong-headed, and he gives 5 reasons. The first reason, and I'll read it to you in its entirety here, he says, lawyers who draft for judges tend to adopt a highly legalistic style, since judges have legal training. Yet, because these lawyers aren't litigators, they almost never interact with judges. They don't know how much most judges detest legalese. And he gives 4 more reasons. Number 2, the judge won't see it. So just a fraction of 1% of all of the legal documents drafted ever get litigated or brought before the judge. The legalese doesn't prevent litigation, which it doesn't. Number 4, the more legalese and jargon that's in your document, the more it's going to be ignored by the people that you wrote it for. And then lastly, the more jargon that you put in there, the more divergent interpretations will arise. So the more dispute there will be over what the document actually says. So this is excellent. It's absolutely true.